We are very fortunate to have today Professor Matthew Steilen, who is at the State University of Buffalo, who managed to get out of all of the snow in Buffalo to come down here just this morning. And he is the Associate Professor of Law and an affiliated faculty member in the Department of Philosophy. So he is a true doctor, having a doctorate in philosophy. This is our effort to expand the consciousness of the school internationally, beyond just simply Baltimore and the Northeast, but to the Midwest. He's actually originally from Minnesota, and I'm from Missouri, and we have Elizabeth Keys here, and Matthew and I all went to Carleton College, where we're very much interested in things, and he's from St. Louis Park, and John is from Mankato, so we'll expand that. And of course, Matthew Lindsay is now becoming a Midwesterner, I'm glad to say. So he's going to be talking to us today about on the place of judge-made law in the government of laws. That's sort of my invitation. He warned me that he is a lover of the common law, but I'll let him speak to you about that right now. He'll talk for about 20 minutes, and then we'll throw the floor open for discussion. And there are chairs up here.
Now, is there a clicker for me to use by any chance? Does
No.
anyone know? Or do I operate it like this? Which is fine, I can do this.
I actually, if we can find the...
I think you can just hit the space
Okay,
bar.
okay, I problem solved, I can do it.
Do we have a... Where's the computer? I can do it.
But I can do this way.
Oh, yeah, you should be able to. Yeah.
It's perfect. Thank you so much for coming to the talk. I'm more than delighted to be here. It was a pleasure to be invited, and I was really looking forward to meeting Jim. We've had an email correspondence. I'll tell you the story of how I discovered him. I just finished a large project on bills of attainder, and in the course of researching that, I read an old student notes in the Cornell Law Review from 1972. And when you read student notes, you never know what you're going to encounter. Occasionally you encounter something that's outstandingly brilliant. For example, the lead piece of scholarship on bills of attainder is a student note from 1962 written by John Hart Ely. And I read this note and I was dumbfounded by how comprehensive the scholarship was, how closely it was read. And I looked to the bottom and I saw Jim's name, and so I Googled him on the plane, was reading this, and I saw that he had gone to Carleton, where I went. And so I just sent him an email gloating about, you know, the fact that we both went to Carleton and how good it was, and he responded, and he seemed very fun. So it's really a lot of fun to be here and to meet him and have a chance to talk to you. I do have a little bit of a sense, though, of being, as it were, invited to be the crocodile's dentist, because as it turns out, he's just completed about a 200-page manuscript on everything that's wrong with the common law. And the topic he asked me to talk about, government of laws, is also the subject of a 300-page book by another one of his colleagues, whose first chapter, at least, is about government of laws. And so I suppose everyone has to serve as red meat, at least at one point in their academic career. So I'm happy to do that today. I've sent a paper that was written just for this, really just very recently, and it's at its earliest stages, and I am more than happy to have you discipline and correct my thinking, or maybe even to advise me to put this to bed. So I'm going to try and explain to you, though, a series of ideas about the relationship between government of laws and judge-made law. The talk is going to have three parts. The first part is an attempt to pose and answer this question, that is, what is a government of laws? The term we're more familiar with today, especially in comparative international law, is rule of law. And I think rule of law and government of laws are overlapping in meaning and overlapping in extension, but they're not co-extensional. One common meaning of rule of law, at least that you encounter in literature today, for example, is the proposition that the lawmaker is subject to the laws which it makes. And that is a proposition that's not usually associated with government of laws. Government of laws, it's connected to that idea, but it's not usually associated to it. Government of laws is really an 18th century term, and so I want to start by looking at how that term is used in the 18th century to try and get a firmer grip on what it means. And it's an ambiguous term, of course. So let me try and identify two different concepts. I think that says concept one. Two different concepts that I see in the usage of the term government of laws in the 18th century. The first of these concepts is a concept I don't think we usually attach to the notion of rule of law, and that is the concept of separation of powers. So here is what is perhaps the most famous invocation of the term government of laws in the late 18th century by an American. This is the Massachusetts Constitution of 1780, Article 30, and you could read there for yourself. I've highlighted or emphasized the language at the end that includes the phrase government of laws. And as you can tell by looking at the passage, at the provision, it's a provision that guarantees the separation of powers. And separation of powers is an idea I don't think we typically associate immediately with rule of law, although again it's connected. It's not the first thing we think of. But it was a very close, it was a close association with the term government of law. So how is it? How is it that separation of powers and government of laws is connected? Well, Adams was influenced by this man, Harrington, who was a Civil War period English writer. And he's most well known now, as he was during Adams' time, for this book, Commonwealth of Oceania, which is a treatise that describes an imaginary commonwealth. And one of the things he advances, one of the arguments Harrington advances in Commonwealth of Oceania, is that a monarchy cannot be a government of laws, while a republic or a commonwealth can. A monarchy cannot be a government of laws, but a commonwealth or republic can. Why would Harrington think that? Here's Harrington's explanation for why a monarchy cannot be a government of laws, but a commonwealth can. Here he is posing the question. The main question seems to be how a commonwealth comes to be, as he says, an empire of laws and not of men, or how the debate or result of a commonwealth is so sure to be according to reason, seeing they who debate and they who resolve be but men. And as often as reason is against a man, so often will a man be against reason. Doesn't, in other words, a commonwealth face the very same problem that a monarchy faces, which is that a monarch or a prince rules in his own interest. He simply advances private interests at the expense of the common good. He does that like any other person does, just because they're human and they're subject to reasoning in advance of their own interests. Here's Harrington spelling out the relationship between reason and government. He distinguishes three kinds of reason. There's private reason, he says, which is the interest of a private man. There's reason of state, very interesting term. Reason of state, which is the interest of the ruler or rulers, that is to say, of the prince or of the nobility or of the people. And thirdly, there's that reason which is the interest of mankind or of the whole. If the interest of popular government come the nearest to the interest of mankind, then the reason of popular government must come the nearest to the right reason. So Harrington is going to argue that the institutional structure of the Commonwealth makes it disposed to come nearest to the common good. For some reason, a Commonwealth is likely to govern on the basis of common good rather than private interest, like a monarchy. Well, why is that? Harrington says it follows from the way in which, in a republic, legislative power is divided. Harrington says you divide legislative power between an upper house and a lower house. You give the upper house the power to recommend laws, because that is the special capability of the people that populate the upper house. And you give the lower house the power to vote on the recommendations of the upper house. You have a situation then, says Harrington, this is the analogy he actually draws, like people dividing up a cake. If two people divide up a cake, you give one person the right to cut the slices and the other person the right to choose the slices. Then you're always going to have, says Harrington, equal slices, because if the first person cuts a bigger slice, the other person will take it. That's Harrington's reason. So in a commonwealth, you're always going to have laws that reflect the common good. Now, he's probably wrong about that. He didn't think about whether or not the cutter of the slices and the taker of the slices will be in cahoots. That's called the party system, right? But that's at least his argument. And Adams picked up on it, and he extended it to the division between legislative power and judicial power. If you don't separate legislative power from judicial power, then you will have the same person making the law as applying the law. And if the same person makes the law and applies the law, then they will eventually make and apply the law to serve private interest, rather than the common good. So says Adams, following Harrington. So that's the first concept of government of laws. And the idea, or the concept, connects separation of powers with the idea of government of laws. There's a second one as well, and I think this one's more familiar and more usually associated with rule of law. Let me put up a text from the 18th century that describes this concept. Here's Jonathan Mayhew, who's a leading Congregationalist minister from, I think, Massachusetts in the mid-1700s. He says, in all three constitutions of government, law and not will is the measure of the executive magistrate's power. By the way, you oftentimes see the phrase free government and government of laws used interchangeably. Okay? In all three constitutions of government, law and not will is the measure of the executive magistrate's power. Well, what is he saying there? He might be saying a couple of different things. Here's three things he might be saying. These might not be all of the things, all the possibilities, but here are three possibilities. He might just mean that the executive cannot break the law. The law is the measure of the executive's power. The executive cannot break the law. Today we have lots of discussions about Lockean prerogative. This is the idea that the president or the executive can suspend the law or break the law, especially in an emergency, right? That there's some residual executive authority to suspend or break the law in cases of emergency. That might be what he's referring to. Maybe he might also be referring to the idea that the executive, these are Waldron's words, governs in a constraining framework of public norms rather than on the basis of his preference. That is to say, he governs under law. What guides the decisions he makes are norms that are public rather than idiosyncratic. Finally, Mayhew might mean something like the idea that the executive acts only after giving process of some kind. And this idea was pretty popular in the 18th century. I think the leading case, early case on the relationship between executive discretion and law is actually Marbury v. Madison. We went through a corrective period in the literature on Marbury v. Madison where they concluded that Marbury actually wasn't an important case. It didn't establish judicial review. In fact, you should be reading Stuart v. Laird, and Marbury shouldn't even be read in common law classes anymore. Actually, Marbury was a very important case, but not for establishing judicial review, but for establishing the fact that the executive is subject to litigation in the courts of law. And the distinction that Justice Marshall made in defending that proposition was between violations of vested legal rights and executive discretion. That is, powers constitutionally committed to the executive. For example, the commander-in-chief power. You can't sue the president for being a bad commander-in-chief. You can sue the president or a secretary of state for failing to deliver a commission to which you have a legal right. That's connected to government of laws. The government of the United States has been emphatically turned to government of laws and not of men. It will certainly cease to deserve this high appellation, says Marshall, if the laws furnish no remedy for the violation of a vested legal right. The idea there then is the executive of the discretion, here embodied in the Secretary of the State, is limited. And part of what it means to be a government of laws is to subject the executive to liability in the court of law for failure to abide by procedures that are laid out in law. Okay, so these are two concepts of government of laws from the 18th century. I'm making a historical claim there. You might think that judge-made law doesn't fare very well according to either of those concepts. So I just put up a very silly little syllogism to show you why you might conclude that a government of laws in either sense is inconsistent with judge-made law. Again, this is not an attempt to do anything that's path-breaking. It's just to try and crystallize our thinking. Here's a very simple syllogism. A government of laws is a government in which, pick your concept, one or two, the common good rather than the private interest prevails, or action follows known fixed rules. Second premise, when a judge makes law, he can legislate on the basis of private interest, right? Or he doesn't act on the basis of known fixed rules. Finally, a government of laws is inconsistent. The conclusion is that judge-made law has no place in the government of laws. This is the idea that I want to address. So the second part of my talk is going to be an exploration of the relationship between judge-made law and executive discretion. I think when we start to think about judge-made law differently, we're going to see that there is a place for judge-made law in a government of laws. And here I'm going to do just a little bit of lecturing to you about some very old developments. I want to start with the origin of judge-made law, which is the common law. And the common law comes really from on the standard accounting, comes from 12th century England. Okay? It's basically an invention of the Angevin kings, and particularly Henry II. This is the standard story that's associated with Maitland. Why did Henry II create a system of courts? Well, when he assumed the throne, it was after a period that English historians call anarchy, in which England was led by King Stephen, and there was a dispute over whether or not he was the proper leader. Stephen's problem was that he governed in the feudal tradition. He treated kingship as a contract. And since it was a contract, when he didn't uphold his side of the bargain, the nobles said, we're not going to show you our allegiance. Okay? And they would act independently, which led to chaos. Henry's innovation was to draw on some of the resources in Roman law to articulate a new basis for kingship, and that was, in particular, his will, his authority. And that is the classic conception of law in the Roman tradition. But this interesting thing happened. When he extended royal authority to provide justice where there had been a failure of justice before, that royal authority didn't act just as a will, it got proceduralized. This is the basis of the common law. So Henry tried to intervene in disputes over ownership of land. This happened a lot after the anarchy. You came in, you violently dispossessed me of my castle, I want it back. He did this by means of a writ. And a writ was just an order. Give them back their land, right? What happened was eventually there arose a kind of arms race where one person would ask for a writ and then the other side would ask for a writ and land would go back and forth. The solution that they eventually found in this situation was to give judicial writs. So Henry started to order the individuals involved in the dispute to show up before his justices, where they would then decide on who the proper owner of the land was. And this is the source of judge-made law. This is where judge-made law comes from. When they showed up before the royal justices, the way they decided whose land it was typically involved a jury. And to allow the jury to decide whose land it was, they had to plead down the contest to a single issue. You only gave the jury a single issue. And in the process of pleading down the dispute to a single issue, the judge made a bunch of rulings about what kinds of defenses were good defenses to a particular writ. And those rulings became substantive law. As the old phrase goes, substantive law was secreted in the interstices of procedure. Okay, that's where judge-made law comes from. It doesn't come from written decisions. It doesn't come from a theory of stare decisis. It comes from judges ruling on the sufficiency of defenses in the common law system. Okay, so what am I showing? What am I trying to show here? What does this tell us? The development of judicial writs shows how judge-made law actually limits executive discretion rather than expresses executive discretion. It limits executive discretion in two senses. First, in a very simple sense, judge-made law in the common law framework, that early common law framework, limits executive discretion because it subjected baronial power, the power of the landholders, to limits described in decisions made in royal courts. Okay? So the people involved in that dispute weren't free to use, as we say in the law, self-help to resolve who owned the land. Their ability to control or possess that land was made subject to decisions of judges. So in that sense, judge-made law limited their executive discretion. In another deeper sense that we don't fully understand, though, something else was happening, which is that when royal prerogative, the prerogative of issuing a writ, became extended in this way, it was made subject to a set of procedures which the people of England began to regard as their birthright. No longer was the executive writ, the writ, just an order from the king. It became a device that every free English person was entitled to in order to get justice. And that development was connected with the fact that it became judicial rather than executive in form. Once the writ
was not simply a royal command, you give the land back to this person, but was a summons to a judicial proceeding in which you had an opportunity to make an argument and the court listened, all of a sudden became regarded in a very different way. So that royal prerogative, that royal power, that discretion to order the land to be given was limited. Limited by a procedure which took on a life of its own. And it was absolutely essential to that development that it was a procedure. Okay? So that's how judge-made law limits, in some sense, executive discretion. So here's the last part of my... Okay, so that's the 12th century. What does that have to do with anything? I thought you said you were going to talk about the 18th century. Well, I turned to the 12th century because I think the relationship between judge-made law and executive discretion is clear there. What can we find in the 18th century that shows any acceptance or understanding of that view? Well, we can't find the same terms, okay? But I do want to defend a set of propositions by relying on the views of James Kent, who was, as probably most of you know, a leading New York judge at the end of the 18th and early 19th century. He became a New York chancellor and really is responsible for developing large swaths of commercial law. He's also really important because he was one of the first judges to insist on reports, that is, writing out decisions and having them collected. And he worked very closely with his own reporter, a man by the name of Whedon, to collect and publish his decisions so he could create a body of law. So he's a classic advocate of judge-made law. Here's what Kent said. First of all, Kent rejected the Adams-Harrington argument that a monarchy could not be a government of laws. This is from his law lectures at Columbia College in 1795. The present civilized monarchies of Europe are governments of laws and not of men. And under them, property is secure, industry encouraged, and the arts flourish. Why? Why were they governments of laws? Well, the protections that he referred to at the end, the protections to property, derive from the common law. So Kent saw their claim to be a government of laws as involving in some essential way the processes of the common law. How could that be if judge-made law is simply an act of judicial legislation? Judge-made law is simply executive discretion or legislative discretion through the office of the judge. How could judge-made law secure property rights? Kent didn't think of it as we think of it today, as a judge imposing his or her own preferences on the people before them. Kent thought about it in the terms provided by the Anglo-American or the English history that he studied. So what were those terms? The best evidence of the common law, according to Kent, are the decisions of the courts of law. Kent says, a solemn decision upon a point of law arising in any given case becomes an authority in a like case, because it is the highest evidence which we can have of the law applicable to the subject. Okay, so we're asking, why does the common law, why does judge-made law allow for protection of property and secure a government of laws? And the first step to answer that is identifying what the common law is. And Kent says you can find what the common law is by looking at decisions. Of course, to Kent, the common law isn't coextensive with judicial decisions. The law just isn't what the judges say it is. What the judges say it is evidence of the law. Is evidence of the law. Well, why would judicial decisions be the best evidence of the law? Because of what judicial decision-making is, as Kent sees it. The decisions of courts of law are the best evidence of the common law because they show what the community regards as its law. The evidence, not judicial discretion, that is the discretion of the judicial officer, but what Kent calls legal discretion. Legal discretion. Legal discretion is different from prudential discretion or arbitrary decision-making. It's not simply imposing your preferences or your private interest, as Harrington would say, on those before you. Legal discretion is confined decision-making whose confinement arises out of the process before the judge. The process in which we have a deliberation under strict rules of procedure about what our law is, about what law ought to be taken up, articulated, and applied to the dispute before the judge. That decision involves discretion, it involves choice. It's not geometric, it's not mathematical. It involves discretion, but it's bounded or confined discretion, and Kant called that legal discretion. The key idea is an idea that comes out of the early common law, because legal discretion is an expression of the normative view of the community as embodied in this procedure. We argue about what our law is. That's the same sense in which the royal prerogative, when proceduralized, became an expectation of all those subject to the law of England. I forgot what my last slide is here. Oh, this is an expression of the way in which the common law is connected to community norms. It's rather colorful. We live in the midst of the common law. We inhale it with every breath, imbibe it at every pore. I'm sorry, Jim. We meet with it when we wake and when we lie down to sleep, when we travel, when we stay home, and it is interwoven with the very idiom we speak. And we cannot learn another system of laws without learning at the same time another language. I find the comparison to language really interesting here. You might think about what the court is doing when it produces novel rules of law, like what we do when we produce novel sentences of English. Almost every sentence you will ever say is a sentence that has not been said before, so says Chomsky. It's novel, but it is recognizably and understandably English, and it will be treated by, so far as you're speaking English, I'm talking to a comparative group here, and it will be English insofar as it is treated and regarded as English by those to whom you speak. In other words, law, the giving of a novel rule of law, has a kind of community expressive function because of the way in which the legal proceeding involves that same kind of recognition. Yes, this is our rule, this is our law, this is how we go on. I think that's my last slide. So here's the conclusion I want. And I think this is supported, not airtight, but I think it's supported by what I've said to this point. If the common law is how the community gives itself its own law, how the community gives itself its law, then it is not an exercise of executive discretion. It's not an imposition of will by one officer, the judge, on us, the litigants, and those to whom the rule announced by the judge are subject. And to the extent that power is made subject to common law adjudication, the space for executive discretion to that extent is limited. Okay? So I think if you think about judge-made law in this sense, then it actually looks like it's at the center of the idea of a government of laws. And I think that's appropriate in the 18th century context. Remember, in the 1790s, the concern was not with judge-made law. The leading concern was with legislation. The lesson that conservative Americans drew from the 1780s was that legislatures could not be trusted unless subjected to the right constraints. And Madison came up with this elaborate system of checks and balances, which didn't work and never has worked, for subjecting state legislatures to constraints. But another type of constraint was the constraint of a proceeding at law, because of the way in which a solemn proceeding functioned to express community norms, rather than to allow, as in the legislative setting, one faction to dominate another one. All right, I look forward to your questions. Please, I don't know your name. Could you just...
Jose Anderson. I'm
Jose.
Faculty here. So I think I largely agree with you, but I'm wondering if someone were to, and I'm not as well read about the original sources, but if someone just said to me in a conversation in a pub or something, you know, isn't this really just the king delegating, you know, his power to do whatever he wants to some other people to bother with it? I mean, you know, is the royal prerogative just a delegation that the king can take back, and he doesn't really have to accept any of what they've done in 100 years to make these wise decisions about property? He just let them do it because he would rather do something else or rather not do it. All he's doing is delegating. He's just retrieving the power whenever he gets it back, as would be his right. And so we'll start with that one, and then just maybe.
I mean, that was the theory that King John operated under, and that was also the theory that King Charles I operated under. Then things didn't end so well for either of those kings. And King Charles, of course, ended up with his head upon the chopping block. It's an interesting and complex story, though, as to how that came to be. And I think there's nothing conceptual, as I understand it, there's nothing conceptual that one could point to rule out what you're describing. Early English law, sort of from the Norman and Angevin periods onward, was characterized by legal pluralism. The common law was one among many different kinds of law, right? So you had the law of the churches, ecclesiastical law. You had martial law, the law of the marches. You had the law of the lords in their own courts and their manors. And over time, the common law, for whatever reason, came to capture the imagination of the English people, so that when the king tried to withdraw that prerogative, he could not. And I think that's a historical story. I don't think we really know the answer. You know, Alan Cromartie has written a really great book on the origins of the English Civil War, and in particular on the role of the common law in that, called the Constitutionalist Revolution. And he said, this is 2006, he says, we don't know why the English became so obsessed with the common law in the 16th century and early 17th century, what they did. Maybe the answer is English nativism. They were trying to articulate how they were different from the Spanish or something like that. But they became obsessed with the way in which they became obsessed with this particular proceduralized royal prerogative, and they identified with it.
And just a one follow-up.
Yeah.
I was involved in some litigation years ago, involved the executive clemency power, okay, which is that's a king thing, right?
Yeah.
You know, to grant just you don't have to be punished.
Yeah.
So in Maryland, the common law tradition, the governor had great clemency powers with no framework. But then you had the statute about parole and who can get pardons and who can have reduced sentence. So the legislature passed a law. The law set up a parole commission that was going to make recommendations to the governor, and he had the discretion whether to grant them or not. He didn't have to grant a single one. There were no mandatory standards. It was all sort of under his grace and mercy.
Yeah.
One governor decided that he was going to say as a campaign thing or whatever, I don't care, I'm going to appoint a parole commission, they can sit there and they can be paid, but I will not read a single file that they send me. You're not going to read the file. So we filed a suit and said, well, you're required to read the file. I mean, you can't just say you won't read them, don't send them. So we filed suit, and ultimately we got a judge to rule, no, you have to read the file, even if you ultimately have the power to say no. Now, question, and again, I'll tell you how to answer this one later. What did we win? Did we read the right to have him read it and use discretion and say, okay, I've read it and I'm going to do what I said in the first place? No. And so, you know, as this helped me fill in a lot of gaps in terms of the ambiguities of what the power meant. But, you know, as a practical matter, you basically want a writ, right, under your analysis. The right to be heard somewhere, to have a procedure. And he says, well, I'm not doing the writ thing today. So I'm wondering, you know, sort of, I guess this is why we keep having these conversations about whether these spaces are left in executive or discretionary power.
Yeah, that's fascinating. I mean, the pardon power was, at the time of the framing, the object of heated dispute between advocates of the legislature and advocates of executive authority, and it represented a major moment of conservative victory for example, the New York governor actually didn't have a pardon power, but to give the pardon to the governor. And what do you get in your case? Do you get just the governor reading the file? If the governor just reads the file and then makes a decision on the basis of some other factor, that's not due process. But the governor doesn't have to make that decision according to due process. I'm really interested.
You had two, I'll tell you quickly what happened.
Yeah.
15 years ago, you had two different judges who ruled on it, and in two different appellate courts reached different conclusions about what he had to do, so it doesn't help you, right? And then it took 20 years finally for legislative reform to come about. That the plaintiff that was in the first case took him 20 years to get the governor to read his file and release him. I'm just basically saying I'm not helping you with what happened with it, but that's the That's the battle, the very
Yeah.
battle over, you know, who has the power, what does it really represent? So the Maryland legislature now is trying to remove the clemency power completely, the pardon power completely from the governor and give it to the parole commission, because they say they're the experts, they should be doing it. So
Yeah,
it's still
interesting.
unsolved.
Yeah, that's absolutely interesting. I'd love to hear more about that. Yeah, CJ.
So first, I would urge you to publish a paper somewhere, because it's, I think, it has a lot of, it's a really nice, neat, pithy encapsulation of a lot of really important ideas. And I'm very sympathetic to the basic thrust of the paper. One part of the paper in the talk that I found most appealing, but also very appealing, but also very mysterious, and I'm hoping you can give us a little bit more of your thoughts on this, is the connection between the community's will, or something like that, the views of the community, and the process of common law adjudication. It's not clear to me where the connection comes from, I guess.
Yeah, I don't know
So,
either.
you know, it's not clear that it comes from just the adversarial process or the forensic,
yeah.
as you put it, nature of the process, because, you know, the lawyers and are looking out for the interests of their clients, probably, and the interests of their clients are not necessarily the interests of the community. Even given that you have opposing sides, it may be that neither side is the interest of the community. So it's not clear to me you can count on the adversarial process to sort of to give that voice. The judge may speak with the interests of the community in mind, or may give voice to the views of the community, or may not, and it doesn't strike me that there's any structural reason to think that certainly American judges now are likely to give voice to the interests of the community as a whole. And if it's a true common law case, then you're not really interpreting any statutes, which might be thought of as giving voice to the interests of the community. Sometimes the way you phrase things and some of the stuff that comes out in your paper suggests sort of a Dworkinian view, that, you know, it's really a duty of the judge to try and fit her decision within the body of law as a whole, sort of a coherence kind of idea that may in some way connect to the interests or to the views of the community to the extent that the existing body of law represents those views. But it's an appealing idea, but a mysterious one to me, where the interests of the community actually come in this, and yet you use that idea a lot in your talk and in your paper. So I wonder if you could
Unfortunately, it's
Stand on
mysterious
that.
to me too. I think as a matter of historical claim, I don't know that as a matter of history, when you're talking about the 18th century, insofar as I've accurately described the views of Kent, I don't know that there is a determinate answer. But I think your question is not a historical question, it's a theoretical question. And I guess I would say this, the way I think about it, I'm starting with the baseline. My first premise is that we regard the process as expressing or describing our law. That's where I start. We have an attitude. We acknowledge what emerges in that process as our law. Why do we acknowledge that? Well, I don't know. I think we have a custom of treating the outcome of litigation as expressive of our law. You might try and explain that on the basis of features of the adversarial system. I think all those features are subject to arguments. You've described some of them. You might try and explain that on the basis of what it is the Herculean judge is doing. I think that is subject to counter-argument as well. But again, I don't start by thinking about, well, under what conditions is the judge or the litigants going to make a claim about what our law is that captures the common good or captures community values? I assume that most people regard the process as expressive in that way. And I assume also that the actors involved, when they're making a claim about what the law is, take themselves and understand themselves to be making a claim about the body of law that is our law.
Now they are also advocates, they also have interests, right? And those interests affect what they are doing. But the attitude is, the custom is to treat that process as expressive. And that only happens when you have procedures. That's the mysterious part of it to me. When you have the king, just to go back to the 12th century, you have the king just ordering land back and forth, you just have an expression of the royal will. But when you have a judicial process and you have judges declaring what the law of England will and will not allow as a sufficient defense to a cause of action, then you have a representative character to the judge's decision that doesn't exist there before. And I don't know how to explain that. I almost take it as a starting premise.
Can I just follow up really,
Yeah,
really
please,
quickly?
please.
You know, it may be that part of the problem is that a lot of the talk, for instance, Chancellor Kent, about this idea of the common law expressing the law of the community assumes a sort of vision of the common law that we maybe don't share anymore. And now I'm thinking in my proceduralist hat, I'm thinking about Erie versus Pennsylvania Railroad versus Swift versus Tyson. If the common law is out there somewhere, maybe it comes from our common practices and dealings with each other, and that gradually is calcified into law, or maybe it comes from God, I don't know. But if it's out there somewhere, just waiting to be discovered, then in a sense we can think about it as our law because, well, there it is. I mean, it's there. And the judge isn't doing anything other than discovering something that's already there. So of course we're going to talk about this as a process of discovering what our law is, what other choice do we have, the law's there. But if the common law is being made in a real sense, and I gather you to be conceding that it is, right? Every time a judge makes a decision on a new point of law, then either it's weird for me to think, it's not clear how we would think of that as a process of articulating the community's law unless the community itself has a voice in that
What do you
process.
mean when you say the judge is making the law? What do you mean?
So,
I mean, that he is articulating or announcing a rule that has not yet existed, or
sure. That's a good question, isn't it?
in that sense, I'm perfectly willing to concede it, but I don't think that gets you to the conclusion you suggested. Again, I tried to draw an analogy to language. The fact that you utter a novel sentence doesn't mean that you're making the language. You are speaking in an existing language. We can even describe using grammar. Like, I guess grammar would be the analogy to some kind of legal hornbook. Why it is that it is you're speaking the language you're speaking. But you're speaking a novel sentence. And you're doing that by drawing on your ability to speak English. And you are going to be treated, there's nothing more to you speaking English than being treated by other speakers of English as doing so. That's what it is to speak a sentence in our language. To be treated as a member of that. That's what's happening in the common law system. We have a custom of treating the announcement of the judge after that procedure as being declaratory or expressive of our law. Not in that the judge has got his finger on the pulse of the community and he knows or she knows the way we do things around here. That's not the way custom is informing the law. Custom is informing the law insofar as it involves a procedure of regarding as or recognizing the output of that process as being our law. It's at the other end.
So that needs more exploration. I look forward to talking more about that. That's very interesting.
Yeah.
So I'm trying to, before you respond to the CJ, my comment was going to be that this understanding of it places an awful lot of faith in the person of the judge, as the kind of channeler or translator of community norms. But your response makes me think that maybe it has more to do with the audience, the judge's audience.
Yeah.
And I wondered whether you could talk a little bit about that. Is the audience required to, or are you presuming or positing that the audience gives, kind of substantive buy-in to the decisions, that is the law that's being enunciated, or is it more a kind of acceptance of judge-made law based on, procedural constraints and the process of giving reasons.
Something like the latter. I don't think it's substantive buy-in in that. I mean, substantive buy-in has got to be part of it. I don't have a worked out answer to your question, which I think is excellent. But substantive buy-in has to be part of it. If you announce a law and everyone says that's not the law, then you failed to announce the law of the community in which you made the announcement.
So who's the community you think about? Is it other legal actors? Because those
There are
seem to be
multiple
the kind of
communities
natural police
involved.
of-
There are multiple communities involved. There are the people subject to the rule, but there are most principally those who those people recognize as having the authority to be involved in the lawmaking process. So it's the lawyers and the judges. Really, the core of the lawmaking process is that procedural practice, that process in which we give reasons about what our law is, and we recognize or take up one of those assertions as being our law. And everyone else says, we recognize that, the result of that, as the law of the community, as the law of the jurisdiction. And so, I mean, I don't know, does that answer work? I don't know yet.
I don't know. I mean, I think one place you might look, and maybe you have, is the debate that took place 20, 25 years ago kind of in response to the insurgent CLS movement. And I remember it was mostly around constitutional law, but I think it may apply in some ways to common law as well. I remember reading a debate in particular between Stanley Fish and Owen Fisk, arguing about whether or not constitutional decision making, and I think you could substitute in judge-made law, is just politics, right? Or is just kind of group, interest group politics or something like that, versus whether it's constrained, right? Whether it's constrained by normative community conventions of judicial decision making in the very process of giving reasons that are required, at least to some degree, to be recognized as valid by the relevant audience.
I don't want to be sucked into arguing, though, that it only becomes the law if everyone accepts it. I'm not making a deliberative sort of argument you see in deliberative theories of democracy, like a legitimate law is one that all reasonable actors regard as being based on compelling reasons. It's not about whether the judge can convince us. It's about the fact that we regard the outcome of that process as being the law. It's just an attitude. It's Hegelian more than anything else. What is the law? It's that which we take when it comes out of this process as being the law. And it's not because there is a watertight argument that I have to accept. It's because this exchange has happened, and I don't know what's the ingredients of that elixir.
I'm Colin, I'm on the faculty here as well. So I had the same reaction as CJ in that I thought, the argument worked perfectly the way you had it up on the screen at the end. If it's the expression of the community values, then, so the if is where the action is. And I'm wondering if your answer to that if, or the way you establish it, is a historical argument that has a really limited shelf life, that basically doesn't apply anymore. From the way that you were telling the story, it sounded like the common law was felt to be the common law because there were all these other possibilities. There was martial law, there was ecclesiastical law, and the one that was the law of the people, the one that was the common law, the one that we really wanted, the one that we thought expressed us the best was this one. Right?
Yeah.
That was the process that we could totally get down with, right?
Yeah.
But then when the other forms just melt away, and there's not a common law as distinct from a different kind of law, then that's just what you accept as law is just a synonym for just law, right? And when in the new order, not when you have a choice between different kinds of laws. It does seem that a community elected judge would seem to fit better that premise of the expression of the community than one that's appointed by the executive, by tenure, all of that. And so I just wonder if the historical argument that you make is totally persuasive to me, but I wonder if that sort of it loses its justification.
Surely it's got to be bounded by historical parameters. And I don't take myself to be making an argument that has any institutional implications for judicial independence. We might think or agree that an appointed judge does an inferior job than an elected judge. We might dispute that independently of everything up here, as far as I understand it. Let me though make one comment in response, which is that in the 18th century there was a great, late 18th century America, there was a great competitor to the common law. It was called statutory law. And there was, and Jim will tell you all about this, there was a movement among the most liberal Americans to wipe the slate clean, to get rid of all the mystery and cobwebs of the common law, and to make a new, transparent American law, right? That was the law that you didn't need a lawyer to decipher. So there was a competitor, and that was a subject of great dispute, whether or not it was even possible to wipe the slate clean and in this radical moment of freedom describe our own political system by writing a whole new body of law. Some people thought you always had a given out there, and that was this tradition. There was a competitor in that respect. Now, whether or not that competitor is sufficient to establish the story I want to tell, I don't know. I just have to think about it more.
Because at least the quote that you had from Kent, it seemed like his concern was not with the community so much as protecting private property, which probably will play into that.
Yes, exactly. That's right.
So the common good is really the good of the property classes.
Yes.
Surprise.
Liz.
This is not my area, that's my preface, but I come at this from a very different perspective because I used to do, quote, rule of law work in Africa way before law school. And I'm wondering if part of the answer to the question, where does the magic and elixir come from, might be revealed by looking at the places where the magic and elixir are not there. Because so much of what we were doing was working on systems that looked on paper so much like the English common law, the U.S. system, and so forth, with no community buy-in. And what is it there? What are the litigants leaving court with there? How is that different? It might be a source for revealing.
Tell me.
But being somebody, I don't know the literature very well, but the international development people are very interested in that problem, and I'm guessing theoretically there must be lawyers who've been working on that. It might just be an interesting comparison and contrast.
Yeah, that's a great suggestion. I mean, the story insofar as legal pluralism in English history is a story of political struggle. And, it took Henry VIII to get rid of ecclesiastical law. So I'd love to look at it comparatively because I'd love to know what the answer to that question was that you posed, if it's the same story as it is in English history.
Well, there's a sort of interesting photo negative of the story you're telling, which is just that the colonial system created a tradition of this isn't our law, and that's been perpetuated with the sort of modern systems that we put on. And so I'm just wondering what happens over there. It's very
Yeah, we had a little bit of that in American history, right? Because the common law had to be actively received by the state assemblies and state legislatures after the Revolution. All the states had an act in one way or another in different kinds of language saying we received the common law in its entirety or this portion of it. Because otherwise it was just the law of a foreign king, a kingdom. But not in the same way, not in the same way. Not the law of the colonizer, although it was the colonizer, not the same way.
Hi, I'm Kim Brown.
Hi.
I'm actually from Buffalo.
Oh, great.
So I had a similar reaction, and that is, I think when you're drawing the distinction between the will of the community with respect to the common law and executive discretion, and imposing that on the American system, in my mind got confusing, because I think of executive discretion as having a political, democratic legitimacy, right? That maybe what you're saying is a sovereign monarch doesn't have. And so some clarification on that just sort of confused me a little bit. And so that contrast, I said, well, okay, the will of the community through the court system doesn't make as much sense to me unless you're talking about a jury trial. which I do think, I don't know the extent to which historically the fact that juries are involved makes the institution more legitimate.
Sure it
But
does.
I also think the other thing that perhaps is a bit of a point of clarification is when we're talking about the validity of the institution, it sounds like you're talking more about the legitimacy of it as acceptable, not so much the substantive law created by it. So it's not
Exactly.
a discussion about whether that law is valid. It's a discussion, we're not going to have the barista at Starbucks make the decision. We have a federal judge make the decision because that procedural framework is one that we buy in as a legitimate framework for making these decisions, regardless of the individual who's in the decision-making chair.
Yeah, I mean, let me ask you this. Do you think the electoral mechanisms for controlling the election of President Obama make you completely comfortable with, for example, exercises of discretion he has in choosing United States citizens to target using drone attacks or something?
Oh, I mean, no, I mean, there's a lot of issues with that. I'm not saying, and certainly Congress is supposed to be the bastion of democracy, and it's not really functioning very well. I teach administrative law, so, now people are
Right.
lobbying agencies, because that's maybe more democratic than even our democratic institutions. I'm just saying in terms of like theoretical, from CJ's point of view, I think of whether it's legitimate or not on a practical level, I think of the democratic accountability system as creating a process whereby, at least in theory, it's more tied to community values in
Yeah.
a real-time way than a judge.
Yeah, I wouldn't say real time. I agree with everything up till saying it's tied in a real time way. I mean, I think what it means to give someone an office, including the office of the presidency, is to bestow on them certain kinds of discretion, which means they have the ability to make decisions and there is no check on those decisions other than election, right? And if the president, in exercising discretionary authority, invades individual rights, kills people, that is subject to rule of law criticism. What people want is a drone court, for example, because they worry about unreviewable decisions, even in the context of a politically accountable
Oh,
executive.
sure, I completely agree with that. I think that's just a different question in my mind too. I mean, when you're talking about a federal judge,
Yeah.
there is, maybe we can agree or disagree on whether, the next election of president is Ted Cruz, if that was a, valid,
Yeah.
Representation of my personal views. I don't know. But I certainly can't go to a federal judge and say, I want someone else. I mean, there really isn't. It's the legitimacy of the institution that is the buy-in of the community, not so much that we either tangentially or directly have any impact on the substantive outcome of that in an individual case.
Yeah, no, we don't disagree about that at all.
Yeah.
Do we have any other questions? Professor Steilen will be around for a while afterwards if you'd like to continue the conversation.
Thank you so much.
He's apparently a book person, so I have a book for him from the Just Gentium series that Professor Sellers and I edited, which is apropos Liz's comment here, The Legal Doctrines of the Rule of Law and the Legal State, parentheses, Rechtsstaat, which is a comparative view of
Thank you
the
so much.
rule of law. So thank you all for attending.
Thank you guys. Great questions.